Hey guys, this is Toby Mathis, and today we're going to talk about protecting your assets like the rich. 4 rules that they don't want you to know, and we're going to go over each of these rules. Before I get started, if you could, like and subscribe if you like this type of content. It really helps our channel out, and it lets me know that you actually like the content. You could also put comments down below. I like those comments as well. All right, number 1, most important concept is you must start before there's an issue. There's no retroactive planning. You have to put things in place before. The wealthy know this. They set things up before there's an issue. If you do not, so like, hey, I get sued and then I start moving things around, you're going to have avoidable transaction issues or fraudulent conveyance issues. And you're going to end up in a much worse place than if you had done nothing at all. But the horse has already left the barn if there's actually liability that comes. And this is especially true when you find yourself on the wrong side of being targeted because somebody perceives you as being wealthy. Sometimes they file these things, if they see something in your name, they know that they can inflict a lot of pain and cause you some suffering and some financial loss simply by filing that suit. And once that's done, it's too late to go out and do anything else. It's kind of the same thing with insurance. You don't get to insure something that's already occurred, right, and get insurance coverage for it. It can't do it, right? So you have to make sure that you have the insurance beforehand, and that's what the wealthy know. They're looking at these things saying strategically, what is our risk? How do we mitigate that? How do we put a plan in place? And they do it very well by starting before there is a problem. Number 2, the rich know to separate ownership from control. These are two very different concepts, right? There's ownership of an asset and there's controlling that asset. And if we can separate those two, we can take the ownership and put it in a protected vehicle, a limited liability entity, a trust, an LLC, corporation, foundation, whatever the case. We can isolate that ownership from the control, the liability that goes along with actually operating whatever that business is or handling those investments. And there are tax benefits as well by setting this up. So for example, if you have a trading account, you may have the trading account owned by an LLC, but it's managed by a corporation that's going to give you tax benefits that it might actually be an owner in the LLC as well, a partner in it. And that enables you to access and unlock a lot of tax advantages that you wouldn't get as an individual simply by separating out ownership and control. Same thing is true in real estate, for example. You might take the ownership of real estate and put it in a land trust, but then take the beneficial interest and put it in an LLC. And if you are somebody that has multiple properties, you may say, I want to cover both ends to make sure that I don't have unexpected liabilities by taking that LLC and having it owned by, for example, a Wyoming LLC out of the state. Now we're making it almost impossible for somebody to go from that property and go into your personal realm, and vice versa. You're making it impossible for somebody to go from your personal realm to get to those assets because Wyoming has charging order protections and privacy, which means we can remove that asset so that by using and separating out ownership and control, you can literally take that ownership and make it completely private. You could still have control of that asset through yourself or a third party. I'll go over that here in a second. But you can actually make it so that asset does not show up anywhere in the public record with your name attached to it, which in my experience, in our firm's experience in doing this for close to 30 years, is probably the most effective technique that you can have. If people don't know what you have, it's hard for them to take it. So you can very easily isolate out ownership and control through the use of the proper entities, which is number 3. Use the correct entity for that purpose. And so I'll just say, use the proper entity. There are different types of trusts. There's land trust, living trust, domestic asset protection trusts. There's all sorts of different vehicles that carry that trust name, general remainder trust. All of them have different purposes and they're unique. It's basically a tool in a toolbox that you can use, and it's very effective. So for example, with real estate, love using land trust to hold title, but protect the asset with an LLC, whether it be a series LLC or an individual LLC. And then I like having that LLC owned by an LLC in a particular state with charging order protections with privacy. For folks that have multiple pieces of real estate, this is a very effective way to get your name off of the property completely. You can use the land trust for anonymity. You can even use an LLC to act as the trustee on your land trust. So you could be using an out-of-state entity that does not have any name attached to it, just the entity itself, acting as a trustee on a trust in your home state that is then in a public record. Nobody can even see this, owned by another LLC that nobody can see that you owned, that's owned by an out-of-state entity. It makes it virtually impossible for somebody to go through that. And I've been doing this with tens of thousands of investors for close to 30 years, never seen somebody actually get through that structure. It's very inexpensive and easy to operate as well when you compare all the benefits. If you're a bigger business, like an operating business, you may be looking at a corporation. In fact, you may be looking at a C Corp because you understand that there's huge capital gain exclusions if you set it up that way. Or you may be looking at it saying, hey, it's kicking down a lot of profit to me and I don't want to pay employment taxes, so you make an S Corporation. Or you understand that, hey, in particular circumstances, I can have an LLC taxed as a C Corp or taxed as an S Corp, and you use the best entity for your purposes. The rich know this, that there's lots of items on the menu, and they pick what's best for them at that particular time. Again, without creating too many analogies, it's a toolbox, and they're picking the best tool for whatever it is that they happen to be doing. And in a bigger business, it might be that C Corp, and it may be that you're looking at a different jurisdiction. So, for example, for publicly traded companies, historically, it's been Delaware. Although the way they treated Elon, they're losing a lot of people. People are starting to leave because you have so much shareholder protection. That's why people like using Delaware, because if I'm going to invest in something, I want to know that I have a lot of protection versus the opposite, which is strong management protections, which might be Nevada or Wyoming. Again, depending on the type of business, you may say, hey, under these circumstances, this is the type of business and this is where we want to be incorporated for our purposes. They understand that. The wealthy understand that. The rich understand that, and you should too. If you're doing an estate plan, for example, almost always, 99% of the time, it's probably going to be a living trust. It may be that you use a living trust and an irrevocable trust of some type as well, but almost always there's going to be a living trust sitting there with the power of attorneys for healthcare, power of attorneys for financial. They have the vehicles already set up in place so that if something happens to them, and they know it's 100% likelihood it will happen eventually, that there is something in place that is proactive that allows them to protect and protect their estate and help whatever it is, their legacy that they're trying to create, allow businesses to continue, et cetera, et cetera. If you're investing in different things like syndications, real estate, stocks and bonds and other equities, even certain smaller businesses, you're probably going to be using an LLC. And again, it might be in a state where there's privacy and charging order protections, meaning somebody can't take the entity away from you, so that there's strong protections for you. That is something that the wealthy consider and take into consideration when they are doing their planning. I've sat with thousands of people and done this type of planning, and you're being very specific. Hey, for this type of business, this is the recommendation for how you would operate it. Under these circumstances, here's the benefits, here's the drawbacks, and here's why this is actually better than your other options. Here's your other three options, right? If you're doing charitable activities, for example, you have a 501c3, becomes very, very simple. You can get very narrow and say, for 501c3, here's the jurisdictions where we may recommend, and here's the type of business. It's going to be a corporation, and we're going to get its tax exempt status via that 1023, and here's how we're going to do it, because we've done it thousands of times, right? It's like you're looking at it saying, for this particular purpose, this is what it is. If it was something else, hey, I'm doing a syndication, very different type of structure. Then we're probably using LLCs. Every now and again, you see a limited partnership flow in there, but almost always it's going to be an LLC. And then if you want charging order protections, it's really simple. There's only one state that has charging order protections for corps, and that's Nevada. Otherwise, you're going to states where there's charging order protections for LLCs, and you're using those vehicles like Wyoming. That's probably our favorite jurisdiction, by the way. Even though I'm standing in Nevada, Wyoming has great protections, no taxes, privacy, charging order protections, and it's inexpensive. Why Nevada has a lot of those things too. They have very similar statutes, but it's a little more expensive. So I like putting dollars in my pocket, and so do the rich. So use the proper entity. Number 4, our last rule and our last major rule, I'll call it a golden rule for asset protection planning, would be to maintain your formalities. Everything goes away if you treat it with disrespect. And formalities is really simple. It comes down to books and records and taxes. Make sure that whatever your state requires, that you maintain that minimum standard with that particular jurisdiction. It might be that you just have to pay an annual amount and let them know who the managers are or the directors are or the officers are. It might be that you're just paying a filing fee and that you're keeping books on that. All entities, whether it be an individual, an LLC, corporation, limited partnership, trust, if it is a taxable entity, it's required to keep books and records, period. The IRS requires it. So you don't even have to sit there and say, what does the state say about this? No, it's identical. You have to maintain what its finances are. So make sure if you need to, you're keeping separate books or bank accounts. So in other words, if you have a corporation out there running as a business, you should not have that bank account in your name. It should be in that business name. And you should be tracking that and having its own P&L and balance sheet on that business. Why? Because that's making separation between you and it, and it's maintaining its legal obligations. It's keeping its books and records as required by the law. So you do not end up with something called piercing the veil. We do not want to have a piercing situation where somebody looks at an entity and you say, hey, I set this entity up 10 years ago. I have an LLC. And you haven't paid any of the filing fees since. It's been administratively dissolved and you have no tax return for it or books or records for it. The courts are going to say, no, it's you. And they're going to pierce that entity. So if all you did, and this is pretty much all you have to do, is the bare minimum, maintain it with the state, you can pretty much, unless there's fraud or criminal activity in some states like in Nevada, you have such strong protections that unless you're doing fraud or criminal, it's not getting pierced. As long as you're paying the state, you're going to be pretty good. They can make all the arguments they want. A lot of these things you can fix even after the date, but you want to make sure that you've created and isolated that asset and that entity and that you've maintained its minimum. There are entities that don't require any upkeep, like your living trust and your land trust, in which case there's nothing to file, there's nothing you have to do. It's literally just holding an asset, which means you're good, right? Usually you're using that in conjunction with an asset protection vehicle like an LLC, which you have to maintain. Or here's an easy analogy. It's like having insurance. Make sure you pay your premiums. If that LLC is your protection and this is your insurance, make sure you're paying the annual premium to the state so it stays in good standing, right? The last thing you want is to set something up and then let it go to the wayside, and just through neglect and not knowing, you let it get dissolved, and then when it comes time to use it, you're like, oh, shoot, I'm not going to get the benefit of that thing that I set up. You got to make sure that you maintain your formalities. And if you do that, you get other benefits. You get tax benefits. You get privacy, which is, again, probably the most effective asset protection tool that exists, bar none, is making it so people don't know what you own. And by the way, you can do that with your personal residence. You can do that with your businesses, your investments. Nobody gets to know what's in your bank account. Nobody gets to know what's in your trading account. Nobody gets to know what LLCs you own. All of that, you can create complete anonymity. In every state, by the way, you can do this everywhere, depending on the activity. If you're a licensed professional, you may have to have, they'll have to let you, you'll have to disclose. But your assets in protecting your investments, you absolutely can keep those completely private if you want to, through the proper use of using the right entity. Again, make sure it's proactive. Make sure that you're separating out ownership and control, especially where there's a huge benefit for you. Make sure that you use the right entity, and then make sure that you're maintaining those formalities. Those are the 4. Share this with anybody you know that's doing asset protection or thinking about it, If you would like to talk to a professional about your situation, just type in free consult down below. Just consult would even be better. Just put it down in the comments. We'll send you a link so that you can have a no obligation consultation with a professional to say, here's what are the options for you for what you're doing. They apply it to your situation and look at you, create a blueprint and all those things to make sure that you know what your options are so you can decide whether it's appropriate for you. If you could, like and subscribe, share this with anybody who you think would benefit. Thanks, guys.